Believe it or not, you have an estate plan, whether you wanted one or not. In fact, nearly everyone does. Well, everyone does. Your estate plan consists of everything that you own: your car, your home, other real estate, maybe apartment buildings, a little rental house, checking and savings account. I know you probably have one of those. Investment accounts, life insurance policies, furniture, personal possessions, all those little tchotchkes that you've been collecting throughout your whole life. No matter how large or how small, everyone has an estate. You cannot take it with you when you die. When that happens, when you die, you probably want to control how these things are given to the people or organizations you care most about. To ensure that your wishes are carried out, you need to provide specific instructions stating whom you want to receive something that belongs to you, what you want them to receive, and when they are to receive it. You will, of course, want this to happen with the least amount paid in taxes, legal fees, and court costs. This is estate planning, making a plan in advance, naming the people or organizations you want to receive the things you own after you die, and taking the steps now to make sure that that plan is carried out. However, good estate planning is much, much more than that. It should also do the following: include instructions for your care and financial affairs if you become incapacitated before you die. Include arrangements for disability, income insurance to replace your income if you cannot work due to illness or injury. Long-term care insurance to help you pay for your care in case of extended illness or injury. And life insurance to provide for your family at your death. Provide for the transfer of your business at your retirement, disability, incapacity, or death. It should name a guardian for your minor children's care and their inheritance. It should provide for family members with special needs without disqualifying them from their government benefits. Very important. It should provide for loved ones who might be very irresponsible with money or who may not even need the money. It should provide protection from creditors or, in the event of divorce, minimize taxes, court costs, and unnecessary legal fees, which could include funding your assets into a trust and designating specific beneficiaries. Importantly, estate planning is also an ongoing process. It's not a one-time event. You should review and update your plan as your family and financial circumstances and relevant laws change over your lifetime. Estate planning is for everyone. It is not just for retirees, although most people do tend to think about it once they get older or they start to get older. Unfortunately, we cannot successfully predict how long we will live, and illness, accidents happen to people of all ages all the time. Estate planning is not just for the wealthy either. Although people who have accumulated wealth may think more about how to preserve it, good estate planning is often more impactful for families with modest assets because the loss of time and funds, money, as a result of poor estate planning can be more detrimental. Too many people do not plan. People put off estate planning because they think they do not own enough. They are not old enough. It will be costly or confusing. They will have plenty of time to do it later. They do not know where to begin or who can help them, or they just do not want to think about it. That happens a lot. Then, when something happens to them, their families have to literally pick up the pieces and try to put that puzzle back together. If you do not have an estate plan, your state has one for you, but you might not like their estate plan. At disability, if your name is on the title of your assets and you cannot conduct business due to mental or physical incapacity, only someone appointed by a court can sign documents for you and conduct business for you, a guardian. The court will supervise and ultimately control how your assets are used to care for you through a conservatorship or a guardianship, depending on where you live. It can become expensive and time-consuming. It is a public record to some extent, and it can be difficult to end even if you recover. You've heard the stories on TV. At your death, if you die without a valid estate plan, any assets owned in your individual name and without a beneficiary designation or other governing contract will be distributed according to your state's laws of intestate succession, typically through a court-supervised probate proceeding. In many states, if you're married and you have children, your spouse and children will each receive a share, even if your children are from a prior marriage or no longer minors. That means your spouse, your new spouse, could receive only a fraction of your estate, which may not be enough to live on. If you have minor children, the court will control their inheritance. If both parents die, like in a car accident, the court will appoint a guardian without knowing whom you may have wanted to be in that role. Given the choice, and you do have a choice here, Wouldn't you prefer that these matters be handled privately by your family and not by the courts? Wouldn't you prefer to keep control of who receives what and when? And if you have young children, wouldn't you prefer to have a say in who will raise your children if you cannot? An estate plan begins with a will or a living trust. A last will, provides your instructions, but it does not avoid probate. A last will and testament only directs how assets titled in your name and without a beneficiary designation or other governing contract will be distributed to your beneficiaries. The assets must still go through your state's probate court before they can be distributed to your intended beneficiaries, your heirs. If you own property, usually real estate, in other states, multiple probates will probably be required, each one according to that state's laws of intestate succession. The process varies greatly from state to state, but it can become expensive with attorney fees, executor commissions, and court costs. It can also take anywhere from a few months to several years or longer. With some exceptions, probate proceedings are open to the public, and your creditors and any excluded heirs are notified of their opportunity to file for payment of a debt or for a share of your assets to contest the whole thing. In short, the court system controls the process and the timing of distributions to your beneficiaries. Not everything you own will go through the probate process. Jointly owned property and assets that let you designate a beneficiary, for example, life insurance, IRAs, 401ks, annuities, and other certain types of accounts are not controlled by your will and usually will transfer to the surviving owners or beneficiaries without probate. The key is that you have to name beneficiaries. However, there are many problems with joint ownership and using these methods for estate planning. In addition, avoidance of probate is not guaranteed. For example, if a valid beneficiary is not named, the assets will have to go through the probate and will be distributed along with the rest of your assets. So your life insurance policy does not have a beneficiary named. If you name a minor as a beneficiary, the court will probably require a guardianship until that child reaches the legal age of majority for the state that they live in, often between 18 and 21 years of age. For these reasons, you've heard me say it before, a revocable living trust combined with a pour-over will is preferred by many families and estate planning professionals. Establishing and funding a revocable living trust can avoid probate at death, including multiple probates if you own property in other states, because everything is in the trust. It can prevent court control of assets if you become incapacitated during your lifetime. It will bring all of your assets, even those with beneficiary designations, together into one plan and provide for increased privacy, protecting you and your family. Because the trust is irrevocable, the instructions governing it can be changed by you at any time. The accompanying pour-over will, like a picture, will be a backup measure in the event that any assets are not funded into your trust during your lifetime. And it also provides that those assets should be poured over into your trust upon death for distribution according to the terms of the trust. Unlike a probate, which will end at some point, a trust can continue for many years after your death, but it has to end. Assets can stay in your trust managed by the trustee you selected until your beneficiaries reach the age you want them to inherit, or longer to provide for a loved one with special needs, to protect the assets from beneficiaries, from their own creditors, from their spouses, and from irresponsible spending, or to provide for future generations. An estate plan that includes both a living trust and pour-over will is not necessarily more expensive initially than an estate plan that only includes a will, but it is more likely to avoid fees and costs later on, considering that a funded trust can avoid court involvement at incapacity and death, and those proceedings can be very expensive. Planning your estate will help you organize your records and correct titles and beneficiary designations. Would your family know where to find your financial records, titles, insurance policies if something were to happen to you? Planning your estate now will help you locate and organize your information and documents, as well as find and correct errors, many people do not give much thought to the wording they put on titles and beneficiary designations. You may have good intentions, but an incorrect error can create problems for your family at incapacity or even your death. Beneficiary designations are often out of date or otherwise invalid. Naming the wrong beneficiary on your tax-deferred plan can lead to devastating tax consequences, costing lots of money. Correcting titles and beneficiary designations now can save time, attorney fees, and taxes for you and your family later on. Estate planning does not have to be expensive. It's vital to understand that trying to do your own estate planning, DIY, to save money now can cost your family more later and have consequences that maybe you did not intend. An experienced estate planning attorney will be able to provide critical guidance and peace of mind that your documents are prepared properly to meet your goals. The best time to plan your estate plan is, well, now. None of us really like to think about our own mortality or the possibility of being unable to make decisions on our own because we're incapacitated. This is exactly why so many families are caught off guard and unprepared when incapacity or death does occur. Don't wait. You can put something in place now and change it later, which is exactly the way estate planning should be done. It's an evolving document. The best benefit is peace of mind knowing you have properly prepared and planned and you have something in place. One that contains your instructions and will protect your family, will give you and your family peace of mind. Estate planning is one of the most thoughtful and considerate things you can do for your loved ones. It is literally a gift to them. It doesn't matter how many assets you have or how much money you have. If you can do a plan, an estate plan for incapacity and for death, that alone can be the biggest gift you give your family. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.